I'm giving the word to you, and we'll be back in 2 minutes and join your conversation.
Sure, thank you very much. I will speak in English, so I was assured that we don't need a translation. But if you want me to slow down and explain a little bit more and slowly, or you need a translation, maybe some of can translate if something is not understandable. I'm very happy to be here, of course, and I have done this also in other countries before, giving a small lectures to a group of students, and I'm happy to do it again, here in Ukraine. My name is Igor Cvjetkovsky. I work as a senior advisor on transitional justice and reparations to the Office of the International Organization for Migration in Ukraine here. By origin, I am from Macedonia, so I can understand a lot of Ukrainian, but I'm too old to learn new languages, and I'm afraid to speak, so I cannot say I speak Ukrainian. I have been working for the International Organization for Migration for more than 20 years now. Most of that time I have been working on the issues which are related to reparations, transitional justice, restitution of housing, land and property, and the linkages with the humanitarian aspects of certain crises around the world, and also with the reconstruction and the development. So before coming here to work in Ukraine, I was based in the IOM headquarters in Geneva. And from there, I have been working and traveling a lot around the world. So I work on the issues of reparations for human rights violations and war crimes and crimes against humanity, and the issues of housing, land and property restitution after a war or after a conflict in countries like Colombia, Sierra Leone, Sri Lanka, Nepal, former Yugoslavia, Bosnia and Herzegovina, and Kosovo, Philippines, and plenty of other countries around the world. So I am a philosopher by education, but I am a reparations practitioner by vocation. So that's sort of my background for you to know. So as I said, I'm happy to be here, and first what I will do is explain what I do and here in Ukraine, and a little bit of what I have done. Then I will talk a little bit about the issues which is very important now and very pertinent for Ukraine, the issues of reparations, and how it has been seen and situated within the national and the international frameworks. And then I will be happy to answer some questions. So before I continue, do you have any questions or any comments?
Sure.
Okay. So thank you very much. So reparation is, I will start from the point of view of reparation because that's my expertise. It's something that can be perceived or interpreted in two ways. Historically, and on one side, of course, you are probably aware about the concept of reparations as an obligation of a state toward another state to pay after they have inflicted the damages during war. Now that concept of reparation still remains valid, and it has been there since ancient times. In history, for example, when Rome defeated the Phoenicians, they were obliged, to pay reparations to Rome, and then, back to very near history, after the First World War and after the Second World War, there is obligation on behalf of Germany to pay reparation, and that happened. And this is sort of the notion about the state-to-state reparation. And that is very much valid for Ukraine because Russia is an aggressor state who has committed a lot of war crimes, crimes against humanity, and gross human rights violation, resulting in a lot of damages and injuries and losses for the country and for the people. They should pay reparations. So there is that aspect of reparation. But in the meantime, also, particularly as of the 80s, in the concept of transitional justice, there has been developing the development of a different type of notion about reparations, which is focused not on the state, but on the victims, on the people who have suffered different human rights violations and war crimes and crimes against humanity. So it is important to notice, and that's what I'm trying to point very frequently here in Ukraine, because I don't think it's clear to politicians and policymakers that there are these two different notions of reparations. So yes, the Russia, in the context of Ukraine, the Russian Federation is liable for paying reparations to Ukraine and its people for what has been done. But Ukraine also as a state is responsible to make sure that the victims get the reparations that they need. Now the concept of reparations, the second concept of reparations, I call it the victims reparations rather than state-to-state reparations, belong to a broader concept which is called transitional justice. Perhaps, during the studies you have touched upon the issues of transitional justice. And transitional justice is generally conceived as a set of measures which are designed, to help societies and countries to overcome some of the challenges, and some of the problems, and address the damages and the violations that have happened during a period of oppression or a conflict, etc. That concept has been developing over the 80s, in particular in Latin America, and it also, to a certain extent, in South Africa after the apartheid regime fell down. And it has several components. It has the criminal justice component, which is also, you have it here in Ukraine and internationally, considering the situation now. And there is also a component which is called truth-seeking, and truth-seeking and reconciliation. That's, I'm not sure to which extent it's possible or desirable to do now in Ukraine. Then you have a broader institutional reforms, and then you have the concept of reparation. So reparation is one of the pillars of the broader notion of transitional justice. Now, looking again, from the perspective of reparation, when you drill down, and I'm talking about victims' reparation, not state-to-state reparation, there are 5 models of reparations, 5 types of reparations, which are being recognized, recommended by the United Nations system, but also applied by many states. And then within these 5 concepts of reparation, there is the notion of satisfaction, then the concept of compensation, which everybody is familiar with, rehabilitation, restitution, and guarantees for non-repetition. Now, in an ideal situation, of course, you would use all these 5 models of reparations in order to address the needs of and the rights of the victims. But that's an ideal situation, and perhaps not all of them are necessary and needed. The most important thing, when one designs a reparation program for people, not for states, is to think about what are the needs and expectations of the people who were affected by the war. And that's something, that is critical. That everybody in the practice and in theory, in the international community and at national level, has been advocating for a victim or people-centric approach in designing those programs. So I think that's sort of one of the key principles as well, which is now being accepted. So look at the reparation as a broad concept, so not only compensation, which is how the way mostly is now perceived in Ukraine by policymakers, and look and design the legislation and everything else with participation and with input, informed input by the people who are affected by this legislation. And that's something that is sort of, ahead. So in Ukraine, that's the area that I work in, and these are the sort of the goals that I'm trying to pursue, and link everything with the international mechanism which has been established for reparation for Ukraine, which is the International Register for Damages, Losses and Injuries established in The Hague under the Council of Europe auspices. Now, just to explain a little bit, because you're students of international politics, and I don't know how much of you have a background also in international law, so, but just to explain about a little bit what is going on internationally now, and how it came to be, and what is to follow, and what is going to be challenges, and what is going at the national level, and how it should look at also what would be the challenges, and how the two can be linked. So, when the war, the full-scale aggression started in February, on 24th of February 2022, the international community, of course, recognized that as a clear violation of the United Nations Charter, and some states were very clear in terms of condemning and immediately considering different measures how to help Ukraine, and you're all aware about that. States have been focusing on supporting Ukraine in terms of defense. States have been providing budgetary support. There is a lot of humanitarian assistance that has been done as well, but there has been also focus on international law and using the international mechanisms that are in place. So typically, you know, the first door to knock in such cases is the UN, the United Nations. The purpose of that organization is to uphold the value enshrined in the Charter, not only in the UN Charter, but all other international law mechanisms, such as the different conventions and treaties, which has been accepted by state parties, and so on. So if there was a different scenario, you know, this issue would have been brought in front of the UN Security Council, and there would have been a resolution. But as you know, unfortunately, the UN, the permanent, Russia is among the permanent 5 members of the UN Security Council, and there are perhaps some other states in the Security Council of the permanent 5 which are not really decided, or they're sitting on the sidelines, or they're silently, you know, supporting Russia's view on this, China, for example. So for this reason, you know, the United Nations system is relatively blocked. There was a United Nations, when it comes to reparation, there was a United Nations General Assembly where all states not participate. There were several resolutions, one including on aggression, which a majority of the states condemned the aggression, the Russian act of aggression against Ukraine. There was also another one later on in November 2022 on the issue of furtherance or right to remedy or reparations for Ukraine. So that was a very important resolution. It was voted with about 90 states in the United Nations General Assembly, but because of the structure of the United Nations system, it was not possible to follow the logical escalation and to bring it to the Security Council, because the result would have been, there would be no result, of course, because it would be vetoed. Most of the claims commissions for war damages, such as the Iraq and Kuwait Commission, and Eritrea Commission, and several other commissions, which have been UN-led commissions, have been established by the Security Council. In the case of Ukraine, that was obviously not possible. So the supporters of Ukraine, which consist of the G7 and then broader than G7, you know, many of the entire European Union, most of Europe, and some other states, you know, they have decided, you know, to create another mechanism, a special mechanism under the Council of Europe. So the solution was UN is not structurally not capable to move forward with this. So let's establish, you know, this mechanism under a different auspices, under a different international organization. The Council of Europe itself was very proactive on the issue. Very soon after the Russian aggression of February 2022, they have decided that they voted to kick Russia out of the Council of Europe. So Russia is not in the Council of Europe anymore. And that's, I think, since June 2022. So they have decided that because there was a lacuna in terms of, you know, the United Nations system, there was not possibility. They say, okay, we are going to use, you know, the mandate that is given to us by the Parliamentary Assembly of the Council of Europe. We can use also the mandate given to us by the European Convention on Human Rights, and we can also leverage the European Court for Human Rights, and we are going to create a special body under the auspices of the Council of Europe. So they have used something which is called enlarged and partial agreements model, and they have convened the states and invited them to participate in the creation of such a mechanism. And most of these states are members of the Council of the Council of Europe states, but there are also some additional states which are not which are not European states, such as Canada and the United States, who came also in support of the creation of the international register. So that happened in Reykjavik last year. There was a decision, and between then and now, the mechanism has been established, and the original concept envisaged that there would be an international register. That's done. It is established in The Hague. It started already working, and then there would be accompanied by a secretariat and by a compensation fund. So these are instruments that still yet remain to be established. And the purpose of this mechanism is to register all damages and losses which was suffered by Ukraine and its citizens since February 2022. And then to, once the mechanism is established, the compensation mechanism and the fund, to administer the compensation for these purposes. So the challenge with the statute of the International Register is that it has some limitations, particularly the ones considering the timing, the application period, the temporal application. Unfortunately, because it's based on the United Nations General Assembly resolution, it does not consider the violations and the damages which happened between 2014 and February 2022. So that's one of the limitations. And the other limitation is that it's envisaged as a typical claims commission, where the rules and the procedures for deciding who is going to get compensation or reparation or compensation are mostly very strict, and they're based on previous international practice. And it's an international body which is distant and which is sitting in The Hague, not really present in the country. They will have some, of course, outreach offices here, but it is not something, you know, they're not really close to the affected population because it's really far. So on one side, it's good to have an international mechanism for the purpose of the claiming the funds from Russia. On the other side, you know, it is good to match this with a national mechanism. And why national mechanism is important? It's important to establish a national mechanism because of the gap, of temporal gap between 2014 and February 2022, and because the work ahead will be huge, and it is unlikely that the international mechanism by itself will be able to do all this work. You are aware about the estimation of damages and losses by the World Bank. You probably are aware about that the OPG, the Office of the Prosecutor General, has about 160,000 cases of war crimes initiated or in the process of investigation now. The International Criminal Court has also initiated some procedures on their side. So, and you know how many people have been displaced and how much damage has been done to individual housing as well as state property. So, if you think about the claims for compensation that will come forward, then you can probably think that they will not be in the tens of thousands. They will be only in the hundreds of thousands, in the range of hundreds of thousands, and perhaps if you put displacement as a as a violation which merit compensation, there would be millions of claims. So that's a huge amount of claims. I have worked in the past on the German forced labor compensation program and the Holocaust victimizers program under which happened under the Nazi regime. So my organization was responsible for implementation for part of this program, and we processed about 300,000 claims. So in order to process 300,000 claims, we had to employ 180 people in Geneva and have 40 missions around the globe collecting claims from people who lived in different countries, but they were still victims for the crimes which happened long time ago. So what I'm saying is that the magnitude of the work, it will be huge, and therefore it is necessary to establish also the mirror on the domestic side, which will help the international mechanism to process this number of claims. The other challenge is that typical claims commission, such as the Iraq-Kuwait claims commission, such as the Eritrea-Ethiopia claims commission, they were focused mostly on compensation. And when we talk here, and I do that often with people who were affected by the war, and some horrible crimes such as sexual violence in conflict, rape, wartime rape, such as torture, they clearly say, compensation, financial compensation is not enough for us. We need another form, another types of help, which fall under the categories that I was mentioning before when it comes to reparation, rehabilitation, restitution. So they all need also different types of support. So the international mechanism can only deliver compensation, and that's the mandate. And the national mechanism should take it further and transform this financial compensation that would be given to the individuals and to state into a broader and more complex and reparation mechanism which would be tuned in accordance to the victim needs and expectations. So that's sort of what is going on at the moment, and that's what's going on at the international level when it comes to reparation, and that is what is going on at the national level. At the national level, there has been several laws which are now in the parliament. The law on damages to housing, land and property, or damages to real estates, has been already adopted, and there is the відновленням, the system through which people can apply and so and so. It doesn't function perfectly from my expert perspective. It needs a lot of adjustment, but it is there. There is a law specific to conflict-related sexual violence, also proposed by an MP, which is in the parliament now, registered, and it will go soon into first reading. And there is a law proposed by the Ministry of Social Policy, which is a law on all human losses, which is also now registered in the parliament and has passed the relevant commission and is waiting for the first reading. So in Ukraine, there is already a process to create a mirror image. What is missing is getting information and engaging the affected population into design of the process. So what my organization is currently doing is working with the Office of the Ombudsperson to create a platform for consultation with the victims, because they should have a say not only in what they want, compensation, psychological support, medical rehabilitation, livelihood support. Many of those people have lost everything, and they have diminished capacity and diminished agency and long lingering trauma. So not only what they want in terms of reparations, but well, 20 minutes, okay. So, but also how do they want it? It's not only about whether they want cash or they want psychosocial support. It's who they want this to deliver. What is the pathway? What is the model? How do they want this to happen? So for this reason, we have engaged with the Office of the Ombudsperson and the civil society to create this platform for consultation with victims. So that's sort of, just to give you an idea about the scope and the width, and I give you some, sort of, historical background of the notion of reparations, and also I told you what's going on now internationally, and there's much more than that, and at the national level. You're also aware that at the international level there has been procedures in front of the International Court of Justice. Two of them. One was in relation between, initiated by the Dutch government and the Ukrainian government in the relation of the downing of the plane back in 2014, and the other one was related to. It was initiated by Ukraine and supported by 30 other states. It was to counter the Russian claim of genocide, because Russia tried to argument the invasion with with a false claim that there is a genocide happening in Ukraine against Russian speakers. So Ukraine submitted in front of the International Court of Justice a counter claim that the Russian aggression cannot be justified based on the Genocide Convention. There was a recent decision, which was, the International Court of Justice issued several opinions, and while they are in some way favorable to Ukraine, they are not fully successful in terms of condemning Russia acts or making sure that there will be a reparation outcome out of the International Court of Justice. You can pursue reparations through the International Court of Justice under certain conditions. It has happened in the past. The most recent one was between Uganda and DRC, and the Democratic Republic of Congo. And I think Ukraine should pursue this path. But there are certain conditions, and the conditions are that either both or at least one of the states has to accept the jurisdiction of the International Court of Justice, not to mix it with the International Criminal Court, that's a different thing. And the second thing is that it has to be based on a international law or a treaty which has been signed by both countries. Now, the Genocide Convention, which was used in the ICJ, is signed both by Russian Federation and by Ukraine. But it has it's one of the conventions that is most difficult to use, and my suggestion, and I have voiced this also to the Ministry of Justice and to others, is to look at other treaties which are being signed by both countries, the CAT, the Convention Against Torture. Both are signed, and others, and then pursue another case in front of the International Court of Justice dedicated to reparations. That will take, of course, some time, to build up, and it takes also a time for the court to make a decision. 10 to 20 years. The same is for ICC. You are aware about the International Criminal Court. There has been 2 warrants so far issued, or several. There was one against Putin and Belova for the abduction of the children and the protection of the children. And there was just yesterday, the day before yesterday, another one against senior officials for indiscriminate targeting of civilian population. So, just a few words on the ICC. You can also secure an opinion and a verdict on reparations from the ICC. The criminal purpose is to ensure a criminal justice, that the individual perpetrator, not the state, so it can only pursue individual perpetrators, is being tried and convicted. And eventually, after some time, going through the trial procedures, they can issue an order for reparation. And that has recently happened in the Ongwen case, and there was an order to issue for Ongwen, which is a Ugandan rebel who committed crimes, to pay 50 million personally. So he's personally held liable to pay 50 million to the victims who were participating in the International Criminal Court. Now, where is the problem now with all these things? The problem is that it takes a very long time to secure through the international justice mechanisms, be that ICC or ICJ, a decision which will be enforceable. And then the question is, when the decision is made, whether it's really enforceable. And if you look at the history of the International Criminal Court, they have issued many reparations orders. But all of the people who have been put on the dock in the ICC, they have declared themselves indigent. They have hidden their money, or they didn't have any money. And then at the end, it becomes a responsibility of the international community through the voluntary contribution to pay into the trust fund for victims of the ICC. So, and it takes a long time. So even, there is an arrest warrant for Putin now. Imagine a scenario like with Slobodan Milosevic, the Serbian dictator who started the war, that maybe after 5 years there is a change of government in Russia and Putin is being arrested. The whole process is going to last for about 10 years. And as it happened with Slobodan Milosevic, he will likely die in a jail cell in The Hague. Now, this is a good scenario actually, that this happens, and in order to get there, it's a long time. So the same with the International Court of Justice, where you can, ask directly for reparations. Yes, it is possible, but it will take time. And the point is that Ukraine and the people who have suffered war crimes against humanity, damages and injuries arising from those, they need reparation now. So that's why a lot of focus is being given to the confiscation of the Russian assets abroad, which has been already under sanctions and which has been frozen. And there is a lot of effort, to start moving those funds in favor of Ukraine for a variety of purposes. Now, there is no consensus on this from legal or from political perspective just yet. Some of the funds, they have been already confiscated, which is a legal challenge for many states, because this could be also against international law. So they have to find the adequate legislation and adequate justification for this. So this has been a challenge for many states. Some of the states have already created such a legislation which enables them to confiscate, Canada for example, and some of the states have already taken an action, and there are 2 billion at the moment sitting with the UK government, which has been the proceedings from the Chelsea sale of the Chelsea football club, by Roman Abramovich. So this fund should go back to Ukraine, particularly for the purpose of reparations for those people who have suffered war crimes against humanity. So that's sort of, I think the very important issue now that needs to be looked at and resolved, and it has it's important from both perspective of international politics and also from the perspective of international law. And I think it's sort of the area where there should be a lot of work and efforts being done in order to make to fulfill the international register goals and the national mechanisms goals to secure comprehensive reparations for all the victims of war crimes against humanity and human rights violations in Ukraine resulting from the Russian aggression. So I hope I give you a sort of a picture, about what is going on and what I have been able to observe. I'm sorry if I duplicated some information that you already know, but if you have any further questions, I think, I have about 15 minutes to answer and to discuss. So thank you very much, everyone.
I will moderate it. So, do we have any questions to our dear speaker? Does anybody have? Okay, yeah, go ahead.
Yeah, thanks. I'd like to ask about the occupied territories and its problems. As far as I know, there are lots of buildings which are rebuilt, renewed by Russia, and lots of documentation is lost, is destroyed, and lots of buildings are destroyed, and there is no way that some commission after their reintegration would have a chance to come and see and to make an audit. And which protocol for such situation?
I mean, this is a very good question. Thank you very much. And this applies both to not only to destroyed property, but also to destroyed lives, to people who have suffered and who are still suffering now in the occupied territories. So, in terms of documentation for those, I know that there has been destruction of the land and property. There has been change of the ownership. There has been new administration and new cadastral records being created, by the occupying authorities and so on. So I know also that many people, they flee without, taking their property documents or other documents with them. When it is war, you don't think, where is my deed of sale or deed of, purchase for my house and so on. So it is very likely, that it will be, yes, difficult but not impossible to establish the historical record and to verify about what happened. First, for several reasons. First, there is already an information in the Ukrainian system about what was there and what belonged to whom. And that is at the central level. It's not destroyed. Second, there is also a lot of documentation about the destruction and the crimes which were happening by many national and international non-state actors, NGOs, human rights defenders, and so on. So they have a lot of documentation about that. Then there has been also international commissions, the Independent Commission of Inquiry. There has been also the investigation done by the ICC. There has been also the investigation done by the OPG here, and there is also different teams from different countries who have been collecting all this documentation. So it's not invisible that, what happened and who did it and what are the outcomes, and that's very, very clear. Now, what's going to be a challenge down the road is for a person who was from the occupied territories, whose house was destroyed, to go and claim if they haven't had their house registered into the national register of land and property. So that would be a challenge. But in international practice, there has been ways to corroborate this information. So let's say I don't have any document about my property. What I can do about it? It's not registered, and I don't have the document, but that was still the house that I built on the land that was owned by my father, and so and you can imagine a such scenario. The ways how this has been corroborated or verified is by secondary sort of sources of evidence. The person would have had an electricity supply connected to it on his name. The person would have had would have been paying taxes based on that particular address. The person would have had an internet connection. They would have, in some cases you can even consider the orders for food delivery, as, if they're sufficient enough, So even if there is a zero documentation, you can still find a way, by secondary documentation to corroborate this. You can also, there could be witnesses, and that could be, from the same community who can confirm. So there are ways how to do this. Now, a lawyer approach would be to question this and say, okay, so these are all, circumstantial, I mean, they're not direct evidence, but when it comes to mass claim processes, when it comes to transitional justice, when it comes to supporting people who have suffered war, there is the different evidentiary standards should be applied. So it's not the standard which is proof beyond a reasonable doubt that you use. It's rather the balance of probabilities. So because it is in the interest of the people and the state that it has a more inclusive approach. It's always better to include 5% of false claims and pay them, rather than exclude 30% or 50% of real claims because of strict procedure. So if you want to have a people-centric and victim-centric approach, then it's better that you adopt a procedure which is flexible and use different verification methods. So I hope I answered your question partially.
Thank you so so much for this question. And now I think we have a room for next one, maybe the last one. Does anybody have a question? You have one more? Okay.
Yeah,
Thank you.
continue the discussion. You said about the change in the ownership,
Yep.
beneficiary. In case we have such situations, when during the period of occupation, the owner has changed.
Yeah.
And let's assume the final owner is also Ukrainian.
Yeah.
How would protocol work in such situation? We should pay reparations for the person whose building was destroyed. But to pay some reparations to the final owner, we need to say, okay, we think that
The primary person, the word is, as Anders said, she's really talking about the primary person.
Yeah.
Yeah, and the last one.
Yeah.
I meant that, how to put this properly.
Is it about secondary occupation?
No, actually about the final person, and she's got.
Okay. I think, let me just, I will spend a few more minutes on this, and I think I will answer your question. So what happens typically in a situation of war when there is a prolonged occupation is that, some people flee, some people stay. Those people which stay, they might be collaborators, but they might be irregular persons. And many of the people that are staying behind the occupied lines now, they are not necessarily supportive of the occupying forces. So that's a very important thing to know. But they have been living for 2 years by now, and for some regions, for more than since 2014, under occupying administration. In this period, not only that the houses have been sold, transferred, built, bought, and so and so. People have been born, they have married, they have been having children, people have been dying, there has been inheriting procedures, and so and so. So you can imagine that the occupying forces would, and they have established an administration, they would be administering these records. Who sold what to whom? Who was born, who died? And it is very important, looking forward toward the liberation and the occupation, that Ukraine simply does not do the mistake that has been done by Iraq and by Sri Lanka of not recognizing some of the documents, the critical documents that have been issued by the occupying force. It would be wrong for Ukraine not to recognize the sale of an apartment if this was not a sale which was based on coercion. So if it was between two civilians not related to the occupying forces, they have decided that they are going to sell the house to each other, that should be recognized. Regardless of whether it was registered now by the occupying forces. So it should be translated into and assumed, included into Ukrainian administration, afterwards, when it happens. More importantly, the personal documents, the personal events that happen in life, the birth of children, that should also, even if it's registered by the occupying forces, it should be accepted or translated, transformed as it was Ukrainian issued document rather by the occupying forces, rather than depriving these people from the rights, that they have. So I mentioned two examples, Sri Lanka and Iraq. They have both done mistakes in this regard. In Sri Lanka, there was a 7-year occupation by the Tamil Tigers of the northeastern part of the country. And then in these 7 years, of course, many things happened to regular people who are not members of the Tamil Tigers rebel force, just living there, and they die, they give birth, they marry, they sell houses, etc. And then the government, when they managed to defeat the Tamil Tigers, said, we're not going to accept anything. So there are people now, children in Sri Lanka, which they cannot access school because they don't have a birth certificate which is being issued by the government of Sri Lanka, and the government of Sri Lanka doesn't want to recognize the document which was issued by the Tamil rebel administration. So you penalize people, in that case, and of course, that could create down the road resentment toward the states and discrimination. The Iraq, for example, case, when after the Saddam Hussein regime, they went for a full change of what they call the de-Baathification. And that de-Baathification process alienated, because the Baathis was mostly the Sunni, most of the Sunni population of Iraq. And it took about 2003, 2004, 10 years to have an emergence of ISIS. And ISIS wouldn't have happened, about ISIS and or ISIL and what they did in Iraq until a few years ago, horrible crimes, etc. And everybody was fighting to defeat them. But they wouldn't have had that military success that they initially had and committed the crimes that they had if the Sunni, if they were not joined by the former generals who were member of the Baath party. Also, the second mistake that Iraq did is also when they liberated Mosul now and this area which were occupied by the ISIS, in terms of treatment of the population who remained there, is that they used the anti-terrorism law, which is very harsh in Iraq, and of course, the ones who were participating in combat, who were member of ISIS, they got death sentences because that's legal in Iraq. But then the problem was that the janitors who were cleaning the streets, that got 15 years in jail. So, now you can think, someone has to do some, take the garbage out, in occupied territories at the moment. Someone has to do, the regular work, fix the water supplies. And they were paid now by the occupying forces to do that. So one has to be careful going forward, in the definition of the collaborator. How do you define the collaborator? Is it a person who simply provides services for a living? Is that a collaborator? Or it's a collaborator, those one who actively support the occupation forces, So I think that's something that needs to be looked. So all the issues around the property and the documentation and the secondary occupation, I think it should be looked from this prism. So I hope I answered in some way your question. It is a very, very important question which needs to be considered by the Ukrainian policymakers going forward.
Yeah, I do have my own question actually,
Yeah.
by the way. And before that, does anybody have their own questions to Speaker?
That would be the last one? Or?
I think, yeah. Okay.
I think I just wanted to rate one permission. So, like at the first talk, I just want to really thank you. Thanks for having you here. That I really appreciate that. Whole colleagues for just seeing you here. I also appreciate that too. Life happens actually. You had Tema before really mentioned this just stuff about processing of claims, which are really adjusting to you. How you really could just really digest that or even information, like in a huge amount, just that hundreds, thousands of claims. How you really digest that? How the whole efforts to that to push that forward, to move on and so like that. Thanks.
There are techniques for mass claim processing, where you have a way to group the claims based on a different criteria. First, you have to have the claims based on the category of claims. So you decide, okay, so there is a land and property destruction claim, there is a claim for war crimes because of wartime rape, there is a claim for torture, there is a claim for displacement, etc. So you need to have this initial categorization, which I think the government of Ukraine and the International Register and also us are working on, and so and so. So then you have this basic categorization, but then you have a way, there is a way to group the claims, and then process them, by not looking at each claim individually. So that's why I say relaxed evidentiary standards is recommended in this case, and going, for example, from house to house to individual to evaluate each individual damage, or asking a victim of rape to submit a a medical certificate about, you know, what she or he has suffered, or asking a victim of torture, you know, to do the same, it's a big problem. It's not only that it is not friendly toward the people, that you put the burden of proof on to the victim. It's also that it slows down the process. If you apply full judicial procedure or a quasi-judicial procedure, which has a lot of commissions and evaluations happening, it will take, you know, I have done this calculation, for example, for Yemen. There were 120,000 cases, and the 9 judges wanted to go through everything, every single detail, and they were convinced that they could make it. This commission was consisting of nine judges, and we did a calculation on Excel on a workshop in a table, and says, okay, so how many claims? This many, you know. So, you know, how many judges? So how many assistants do we have? And then, you know, we do the calculation, and then it tells, okay, so it will take you 120 years to resolve this problem. So you need to expand the capacity and change the procedure.
Yes.
So there are 2 ways to do it. Either you have million people working on it, which is horribly expensive, or you create procedures which are simplified, and you group the claims in a different ways. So easy, difficult, has supporting documentation, doesn't have a supporting documentation, and then you decide in a batch, and then you do it, and that's the way.
I see. Thanks. Makes a lot of sense.
Thanks. And my last question will be the following. Here we have been talking mostly about the government, about the society, and the international institutions. But what about the NGOs and other civic society representatives in terms of the whole system of the reparation, in terms of including them toward the bargainings, towards the negotiations and discussions? So what's the role of the think tanks in the system of bargainings on the reparation?
I think very important, and this has been historically proven. They have played a very important role in some countries. In Colombia, for example, victim associations, civil society organizations, NGOs, they have been all part of the shaping of the process. Colombia is probably on paper the best example of how do you do reparations. It's very nuanced, very delicate approach, very complex, fully inclusive, etc. The problem is with Colombia is that it's so good that it requires a lot of resources, and the resources are not there to do it. But going back to the questions, the NGOs, the civil society organization, the think tanks, they can and they should play a huge role in shaping this, because the matter of reparation, I often say it's a whole of a government approach, but rather it's a whole of society approach. So you cannot make a decision, you know, without, you know, having a social consensus on this matter. And I think what is the role of the NGOs and the think tanks and the civil society organizations and victim associations that will start appearing in Ukraine soon, and some of them are already there. You know, the role of this is to advocate, you know, to the government to make the right decision, to bring the right legislation, you know, in place, you know. But that's not only limited to that, also to monitor whether the government is actually doing what they're saying that they will do, based on the legislation. And in some cases, the government wouldn't have a capacity to reach to certain categories of victims or provide a certain type of assistance. So there are many different NGOs. So there are the think tanks, then there are the assistant, you know, the NGOs that provide assistance. Some of them are very centralized. Some of them are very localized. So they all have a role to play. And some of those localized assistance-based NGOs, they can actually deliver on behalf of the government. So if the decision is to provide a psychosocial support as a part of reparation, the money has been provided through the international register, it goes to the government mechanism, the government gives to the NGOs who are closest to the victims and who the victims trust to deliver. So it's both ranging from advocacy, then, you know, to forming the policies, to actually delivering reparation. So it's a very vital role that NGOs can play, and they have played, and I think they're already playing in Ukraine. You know, there are many NGOs, you know, the Helsinki Union, there's Mina and others, you know, who have been focused on this issue, and they're playing an active role.
Mr. Igor, thank you so much for this brilliant lecture and the conversations with us. Thank you for joining at first, and I hope that we have a KPI here actually. I'm telling you every time, the KPI of 1, we need at least 1 brain to be fooled with ideas. I think there will be definitely one among us who will have a brilliant idea about what we have just discussed. Maybe this would be the potential project for the thesis while doing the research for the university, or any idea related to that. So guys, thank you so much also for joining us, and I think have a nice day.
Thank you. Thank you.
And now, roller procedure, I forgot about one more, also the most important thing, taking a photo.
Yeah.
Let's take a photo together. I think